Good evening. This is John Milburn for Laws 12059 Conveyancing. We're into week 4. Thank you, those that are joining us live. I appreciate your attendance. And those of you that are watching this as a recorded session, please consider joining us for the live session Wednesday evenings, 6:30 p.m. I do hope that you reflect on the information that we talk about each week. And when I say reflect on it, I mean think about it from a practical perspective. One of the things that you've noticed is that I try to bring in some cases so that you can think about how these laws apply in practice. Before I leave an area of practice that we discussed, I just want to highlight sections 191, 235, 192, 194 and 202 of the Property Occupations Act. Now, we talked about these sections before, but I'm just wondering if the context of what we discussed has really sunk in. Okay, so a refresher. Can anyone tell me in broad terms what those sections mean and how they might be used in practice? If you were listening carefully last week, you might know. I know that's a cryptic way to start. It's pretty tough. Put it this way. When you're dealing with conveyancing, I guess there are a couple of aspects to it. It's layered a bit. And what I haven't been teaching you is how to complete the forms, partly because that's not what I do. But that's not to say it's not important. It's very important to ensure that you complete the forms correctly. But what I want you to do throughout this unit is think about what to do if something goes wrong, and importantly, what would you do about it or could do about it? And thinking about those aspects will help you to better advise the client from the outset, knowing that certain things can go wrong and having an appreciation of what you can do about it. So Part 10 of the Property Occupations Act, sections 191 through to 205, deal with the power of the District Court to grant injunctions, to deal with undertakings, preserve assets, and impose penalties. Undertakings, we should all know something about that. Very common. Lawyers provide undertakings either directly or on behalf of a client to do certain things. So, Part 10 of the Act gives the District Court power to grant injunctions, to deal with undertakings. Granting injunctions, very powerful, and section 191 and 192 together allow the court to grant injunctions. Good one, Sarah. I was coming to that, so that's good. Give the power to the court to grant injunctions for a contravention of the Act or prescribed conduct provision. Sarah has quite rightly pointed out, section 235 deals with the conduct standards. So I think you need to read those sections carefully. You need to be aware of these conduct standards, because in advising clients, if you believe that someone has done something contrary to the Act and your client is affected adversely as a result, then you must, if you're fulfilling your duty, speak with your client about the possibility of seeking an injunction from the District Court. Your client may not be interested, but at least you're fulfilling your duty to provide the advice, and to provide the advice you need to first know about it. So the injunction can be against a respondent who is engaging or is proposing to engage in conduct that would constitute, amongst other things, a contravention of the Act or conduct provisions. Now that is really very broad, because the Property Occupations Act is huge. The conduct standards expand on that. And who can apply for an injunction? Well, the Chief Executive, but more importantly, in the context of you giving advice in conveyancing, a person aggrieved by the respondent's conduct. So there are many people, including lawyers, who could become respondents in an injunction application, and there are many people that could become the applicants, the aggrieved, that is someone who's simply affected adversely as a result of something that someone else has done incorrectly or contrary to the terms of the Act or the conduct provisions. Now, you need to look at the misleading or unconscionable conduct by marketeers in relation to residential sales, as we mentioned last week, that includes those people that advise, which includes legal. And also think about sections 207, 208 deal with misleading and unconscionable conduct. Okay, so that's where I think we were up to last week. Section 209 of the Property Occupations Act deals with false representations or misleading conduct relating to residential property, and Section 212 deals with false representations about property. So they're slightly different provisions. Subsection 12 or Section 12 carries with it penalty provisions, 540 penalty units, so it's pretty steep. Whereas you find a different remedy in dealing with Section 209 because it talks about looking at Part 9 for remedies for contravention. So have a look at both those sections which deal with issues to do with false representations and conduct about property or property, residential property. And think about how you might use these provisions if called upon to give advice or provide a solution to a client. So it follows on, if you like, from what we've been discussing. Section 225 provides for proceedings for an offence, and there are time limits before the offence can be brought before a justice. There's a reference there to indictable offences and summary matters. So I think we know the difference between an indictable and summary. So you've all done criminal law? Okay. So we're going to move on from agents, and just one last question. Can anyone tell me how much you would pay a real estate agent to sell your property? What's the going rate? It's a bit of a trick question. Depends on the agreement, says Leonie. Yep, I like that answer. Now, was Sarah put in 2.5%? Was that your answer, Sarah? Any others? Any other thoughts? I can tell you what it used to be. It used to be, and Sarah's very close, it used to be 5% on the first $18,000 and then 2.5% on the balance of the purchase price plus GST. That was, if you like, the prescribed maximum, which effectively became the rate. So with the introduction of the Property Occupations Act, those commission rates were effectively scrapped. So now it does depend on an agreement. So there's no specific sliding scale, there's no specific rate, and the indications when the Act was introduced were that nationally commission rates averaged about 2.2%, which was lower than the rate being paid typically in Queensland. So Leonie says competitive in New South Wales, so it's 2.5% or maybe 2%. So it is still, it's much more of an open market now. All right, so let's talk about sellers' disclosure obligations in general terms. We've talked a lot about the agent's duties, but sellers have duties as well. They must provide certain disclosures to a buyer in certain circumstances. But you need to be aware of what those circumstances are in order to properly advise a prospective seller or buyer. Have a look at the prescribed reading and think about the legislation that may be relevant in these circumstances. So in your study guide, week 3, you'll see a reference there to the Queensland Building QBCC, Queensland Building Commission Act. Have a look at the Environment Protection Act. Have a look at other legislation that may have a bearing on issues to do with the disclosure of a seller. And we'll come to a case that I want you to consider shortly. So in the readings, you'll see some key terms. There's reference to defects in title, reference to defects in quality of title. Does anyone know the difference between the two? What's a defect in title as opposed to a defect in quality of title? I guess you could read the key terms in the study guide to tell me. All right, so defect in title, you'll see this in the cases a bit, really relates to interests which are things that are on the title or could be on the title, such as leases, mortgages, easements, and statutory charges. But you'll note that whilst I'm talking about legal interests, when I mention those things, legal in the sense that they're on the title deed, they can also constitute equitable interests, which still are defects in title if they adversely affect a property. So defect in title is not just those interests that are recorded on the title register adversely affecting the interest, they can also be equitable in nature. Do we know the difference between legal and equitable in this context? Or do we find that confusing? In short, perhaps I could ask you to think of it this way. If I refer to someone having a legal interest in land, an interest at law, it effectively means that that person has complied with the legal requirements to register the interest. So a registered owner of property or the registered proprietor of a mortgage or an easement is one that has a legal interest because they're on the title. If they're equitable, it means that they perhaps have not been able to perfect the registration process for whatever reason, but they still have an equitable interest in the property. So defects in title can be legal or interest or equitable. Defects in quality, right, so yes, some good answers coming through. Rachel says defect in quality relate to buildings, etc. Encumbrances, etc. Yes. So defects in quality really are those things that might affect the use or to some degree the value of the property to a buyer. So it's a defect in the quality of the title. So it may be that someone can, for example, own a property without any encumbrance and therefore have no specific defect in title, but it may be in the quality of the title because of the limitations as to what they can do with that property. In the key terms, just following on a different topic, there's reference to proposed allotments and proposed lots. That's now superseded. It's a reference to the Land Sales Act. We'll deal with that now. And the Land Sales Act previously distinguished between proposed lots and proposed allotments, but now there's no longer that distinction, and a proposed lot is something which is, if you like, a catch-all. Okay, so we'll talk about the Land Sales Act. Has anyone dealt with this in practice? No? A little bit? Okay. So the Land Sales Act is important for developers, and it relates to the laws about the sale of, if you like, flat land subdivision. So when I talk about flat land subdivision, I don't mean literally flat, but I mean as opposed to a strata title. So a subdivision of residential land, for example. And this is regulated through the Land Sales Act, where there are legislative constraints upon a developer as to when they can sell land, which is not yet subject to a separate title, and the disclosure obligations imposed on them. There are similar rules that apply through the Body Corporate and Community Management Act in relation to the sale of body corporate units. So in essence, what we're talking about now for the moment is the off-the-plan regime of selling property that is not yet subject to a legal title, but the developers want to secure contracts at an early stage. So we're all familiar with that concept. So the place to look, the Land Sales Act, starting point, have a look at section 10. A proposed lot, if a seller wants to sell a proposed lot, they must provide a disclosure plan and a disclosure statement and a copy of the plan of survey approved by the local government under the Planning Act. So we call that process sealing, the sealing of the plan. So it's not going to be, it's not a title yet, but at that stage, the developer is entitled to sell the property subject to the disclosure obligations. There are some exceptions to it. Large transactions or sales arising from reconfiguration into lots, not more than 5 lots. So if you've got a subdivision of 5 lots or less, you need not comply with the Land Sales Act. If you've got a subdivision of more than 5, then you do need to comply with the obligations under the Act. So the developers disclose certain things about the property in this off-the-plan contract, and the buyer is entitled to know whether the property that they ultimately receive is consistent with the disclosure. And if there are some changes that occur, and sometimes they do, then the developer must provide adequate notice to the buyer, and there may be an opportunity for the buyer to terminate the contract. There are time limits as well, 18 months, for example, to have the matter resolved. So I'll leave you to look at the Land Sales Act from a practical perspective. If you want to be involved in conveyancing, acting for developers or acting for people that are buying from a developer, you need to consider that legislation. Just a word of warning, if you're acting for a buyer in relation to a development which is new from a corporate developer, from a commercial developer, be aware of the GST ramifications, because your client may end up having to pay 10% more than they thought they were going to, because the contract price may not be GST inclusive. Just be careful of that. Okay. So under the Body Corporate and Community Management Act, again, we have disclosure obligations. We have the provision of a disclosure plan, provisions as to when the property is to settle, usually a sunset date, which allows parties to terminate the contract in the event of the developer failing to complete a project within a certain time. Development contracts, particularly for body corporate units, tend to be quite detailed, very professionally prepared usually, and large in terms of detail, quantity. They're large documents. Advantages for a buyer off the plan. Well, an opportunity potentially to buy something down the track at today's price in the event of the prices going up, and being able to plan towards that. Advantages for the seller. Having pre-sales means that they're in a better position to commit to the entire project, and it may be a requirement of their financier to have a number of pre-sales. Sometimes, not always, but sometimes the buyer can do very well by purchasing off the plan, because they're committing to something at a time when the seller is very keen to secure a number of contracts. Okay, so in terms of sellers' disclosures, we've covered now the off-the-plan obligations, both pre-contract and on an ongoing basis. Consider the Land Sales Act and the BCCM in that regard. But what are the things that generally a seller needs to disclose to a buyer, or directly or by implication? Well, they need to be the registered owner of the property. Sometimes they may not be the registered owner at the time. They may become the registered owner, and there may be some disputes involving that. Usually that's a matter of a special condition. So some examples of where someone might wish to commit to a sale even though they're not the registered owner: if there's an estate administration, or if they have purchased the land but it's not yet in their name, and there may be 2 settlements going through at the one time. Sellers need to be in a position to confirm that they're capable of effecting the sale, that there are no unregistered encumbrances, leases or other dealings, and there's nothing relevant to the property under the Environmental Protection Act. So they're just some of the things that a seller would need to do in terms of a commitment to a buyer. Sometimes the buyer has the right to terminate the contract as a result of a breach of a warranty, Other times, an ability to claim compensation. Or, alternatively, an ability to affirm the contract and perhaps sue for specific performance and/or damages. So when a contract is terminated, usually the buyer has an obligation to make an election. Is the buyer going to terminate the contract and affirm it, or to rescind it? We'll talk more about that later. So in the standard contract, there are some aspects of a property being adversely affected that might have a bearing on the conveyancing practice. I'll leave you to read that in the notes. Some of the legislation, Queensland Heritage Act, the Foreign Acquisitions and Takeovers Act, which relates to Foreign Investment Review Board. So, and sometimes land might be subject to a proposal from a competent authority, such as transport. But there is this general obligation to have to be able to disclose certain things, and as a result of that, if you're advising a client, you'd probably want to create some sort of checklist to make sure that the buyer or the seller is aware of the obligations that they have in terms of disclosure. The seller's obligation on disclosure is usually subject to the buyer having the right to undertake searches after the contract is signed. In Queensland, we tend not to do many searches as a buyer before we sign the contract. So it's designed to be sign the contract, rely on the seller disclosing certain things, such as defects in title, and the buyer then undertaking searches. But usually the seller does not have to disclose defects in the quality of title. So there's a really key difference, opposite in New South Wales, yeah. So a really key difference in terms of what a seller needs to disclose, what they need not disclose, and for you as conveyancing, if you're practicing conveyancing, you therefore need to understand what is a defect in the quality of title, which is disclosable, as opposed to a defect in title is disclosable, as opposed to a defect in the quality of title, which is not necessarily disclosable. Okay, when I was much younger and playing rugby, my coach, and this always stayed with me throughout my professional career, he would say to the team, all right, when you're in your defensive 22 or your attacking 22, I want you to sharpen your focus and really concentrate. So throughout this unit, if I say, okay, we're in the 22 now, that's code for, okay, really pay attention now. I'll probably say really pay attention now. What I'm leading to is we're up to case number 6. So we're ready for this scenario. I want you to listen carefully. Feel free to make some notes, and then we'll see if we can answer this in accordance with the law as it stands. Assume you act for buyers of property. Your clients come to you and say that the expensive property they've just purchased is riddled with termite damage. But they say none of that was obvious to them at the time of inspection. Upon engaging a building contractor after settlement, it was obvious to the buyers that the sellers had just patched up the property, the damage to the property. Through the agent, the seller says he did tidy up the property a few times over the years, even before he decided to put the property on the market. And that was to keep up the appearance of the property and not to deceive the buyers. Now, the seller, of course, needn't have said anything. The settlement had already occurred. You went to the agent, said, what's happened? The agent said, look, I'll go and check with the seller. The agent reports back to you, that's what they said. Okay, so what can you do? What advice would you give to your clients who've purchased this expensive property only to find that it is riddled with termite damage. Any thoughts? Would you say you've got a definite case? If so, what would we do about it? And Leonie says, building a pest. Now let's assume that we've already settled. We've already settled on the transaction. And it was only as a result of getting a building contractor after settlement that we found out that the sellers have patched the property and the damage. Think about it from the perspective of the buyer. So Rachel says, no way, get a builder to fix. And Rachel, that means what? Just accept it? Bronwyn says, buyer beware. Sarah says, no case. Should have made the contract subject to building and pest. And Rachel said, yes. No case, get a builder to fix. All right, so we've got 3 votes in there, I think. I think that's all. And everyone's saying, no case. Caveat emptor, let the buyer beware. You should have done something at the time of signing the contract to incorporate a special condition and major inquiries before you settled. I think you're all right. I think I agree with that. The case that you might look at is Wood against Balfour, 2011 New South Wales Court of Appeal, that's NSWCA 382. The question, as determined in that case, is whether knowingly concealing cracks or defects with the intention of deceiving the purchaser and obtaining a sale may expose the sellers to an action in deceit. In that case of Wood and Balfour, there was statement of an obligation on a seller to disclose significant latent defects in the quality of title. That case relates to this question of whether there was this obligation to disclose significant latent defects in the quality of the title. Not the title, but the quality of the title. And the buyers did lose, and it highlights the difficulty of a buyer proving the evidence of deceit in making representations about quality. And it does reinforce that rule of caveat emptor as an article of faith for every buyer of real estate. So in that case, the judge said, to be successful, the buyer would need to prove that elements beyond just knowledge and non-disclosure were present. Although Mr. Balfour did repair some cosmetic damage caused by termites, the court said he was not aware, or at least it was not established by the plaintiff, that he was aware of any substantial damage done by the termites and therefore was not dishonest. So what that case tells me is a few things. The first is it's pretty tough to make out a case for deceit. And it also says, as you've identified correctly, let the buyer beware is still very much the rule of contracts in Queensland. Rachel says some building and pest reports are very ambiguous, and I accept that, in that, bear in mind, I guess, from the perspective of the report writer, there will be a lot of qualifications because they'll say things to the effect, I haven't been able to inspect behind the walls to any degree or at all. So there's not much you can do. Sarah said you can get advice from the builder though, yes, and may not be habitable, for example, is an issue. Yeah, so there are opportunities to argue the toss, but the starting point would be, if you're acting for a buyer looking at real estate, let the buyer beware. In Kadisi and Jankovic, which is Kadissi against Jankovic, Jankovic, 1987 Victoria Reports, VR 255, the seller made no statement about the structural soundness of the home unit in the building, but there were structural defects and there were cracks that were visible on the exterior walls. The seller didn't attempt to conceal the cracks, and the court said, probably not surprisingly, The buyer is not entitled to terminate the contract because of the defects. The buyer should have been on inquiry to make further inspection upon viewing the exterior. You see the cracks, it puts you on notice, can't complain. That situation, and probably the situation in Wood and Balfour, would be very different if the seller had made specific warranties as to the absence of such defects. Do you agree? So if there had been a warranty in the contract in the first case, I warrant that this house is not adversely affected by termites, different kettle of fish. Likewise, in the second case, I warrant that there are no structural defects associated with his building, different case altogether. So what does that suggest to you if you're acting for a buyer who comes to you for advice in relation to the acquisition of, say, a home or a home unit? Is there anything we learn from that? What do you think?
Depends if they come to see you before or after they've signed the contract.
Yes. And in a way, it's much more pressure when people come to you before the contract, isn't it? If they come to you after the contract, you can say, well, if I'd seen the contract beforehand, there's something I could have done, but you signed it. But the pressure's on if they come and see you before the contract. So I would recommend that anyone who's looking to buy property should consult a lawyer beforehand, because that puts the pressure on the lawyer, not the client. But let's assume that they come to you before the contract. Sarah says, make it subject to a building and pest condition. Just always do that. I think that's a good idea. You can choose to use it or waive it. That's another thing. And you can waive a condition. If the condition is for your benefit as the buyer, you may waive the benefit of that. There's no problem with that. So you don't have to go through with it. All right, what about this? Those cases that I've mentioned, they suggest to me that if you're acting for a buyer, you should attempt to include warranties relating to the quality of the title. Now, it may just be a pro forma. You know how the seller might say, oh, it's just a pro forma condition. Well, maybe the buyer should start having their own pro forma conditions and a warranty. Look, I don't know if there's anything wrong with this house, but it's just a pro forma condition. Warranty, there are no termites, there is no structural defects, the electricals are good, etc. At least it gives you an opportunity as a buyer to do something about it if something goes wrong. Yeah, I tried that once, but the seller said, get lost. Exactly, and that is part of the problem. That's part of the problem. So it makes it very difficult. All right, but good point. Now on page, what I want you to do is now have a look at your standard contract, if you would. Have you all printed the standard contract? And if not, I think you should. So I'm referring for convenience to the 14th edition. I know we're up to 15 in Queensland, but okay, so just the standard REOQ contract is what I'm referring to. If you're watching this as a recorded session, please stop, print the contract, have it handy, because remember what I said in week 1 when conveyancers would come to me, I've got a problem. What do we do? What's the first answer? Can anyone remember? Read the contract, exactly. So that's what we need to do. So in the conveyancing unit, read the legislation, read the study guides, but always have it, have the contract handy. On page 3 of the standard contract, you'll see that there is a section at the bottom dealing with matters affecting property. It refers to title encumbrances. Is the property sold subject to any encumbrance? Well, only those that remain on title, please, in that section. We talked about that last week. Note the warning, and look, this is important. See in the fine print, I've highlighted that warning. If you see warnings in the contract, don't gloss over them, read them carefully. They give you a lot of hints. So warning to seller, you're required to disclose all title encumbrances which remain on title after settlement, even though they may not appear on a title search. So what do we mean by an encumbrance? Well, again, just have a look at this drafting technique. In that section, matters affecting property, it says cap title, cap encumbrances. Is the cap property sold subject to any cap encumbrances? You know, I've got this thing about overcapitalising, but there is a very good exception to overcapitalising. So why has this document been drafted with the word property, capital P, and the word encumbrance with a capital E? Can anyone tell me? They've been defined. Thank you, Sarah. That's exactly the answer I'm looking for. And where are they defined? Is it in legislation? Is it a rule of practice? So where are they defined? We don't know. We know they're defined because it's in capital. It starts with a capital. But where do I find these definitions? Okay, have a look on page 6. Clause 1, definitions. There it is. Andrea just got there at the same time. So have a look at page 6, definitions, and you'll see all of the terms that you need. Now, encumbrances is defined, and you'll see that encumbrances includes unregistered encumbrances, statutory encumbrances, and cap security, cap interests. So what does that tell you? It tells you that when we talk about encumbrances and the seller's warranties in relation to encumbrances, we're talking not only those that remain on title, but we're talking about unregistered matters as well. Unregistered encumbrances, statutory encumbrances, and this thing called security interests. Now, why? I think you all know the answer to this, but why is the word security capitalised and why is the word interests capitalised in the definition of as it appears in encumbrances? Can anyone tell me that? PPSA, yes, Leonie's onto it. How did you find out it was to do with the PPSA? Did you just know that, Leonie, or can you give me, what's your authority for that statement?
Foundations of Property Law last week.
Yes, absolutely, it is. But in the context of this contract.
Yeah, I don't know. I don't have it in front of me, sorry.
No, that's all right. But you could take a guess. And Andrea's onto this, the definition of security interest. So you'll see that what we've explored there is the fact that we can have a definition within a definition. Just be very careful to watch that. So if you have a question in an examination relating to conveyancing, and I ask you to consider the question within the context of the parties having signed the 14th edition of the standard REIQ contract, and there's something in it that relates to chattels and improvements, I would expect that you would be on to the definition of security interests, and meaning those security interests registered on the PPSR over included chattels and improvements. Okay, so just always think the contract. And even then, in the definition of security interests, included is capitalised, chattels is capitalised, and improvements is capitalised. So you'll see that these definitions bounce around and refer to each other. A word of warning on page 4 of the contract regarding pool safety. Have a look at the warning, and it says, failure to comply with pool safety requirements is an offence with substantial penalties. That's the warning to the seller. That's different, isn't it, to the warning of the first one. In the first one, where I said matters affecting property, what I didn't read was the final bit, and said, failure to disclose these items may entitle the buyer to terminate the contract or compensation. That's what it says in that warning statement. This one simply says, warning, if you don't comply with the pool safety requirements, it's an offence. So why would they say different things in the warning? Are you with me on this? Do you understand what I'm saying? The first one says the buyer may do things. Second one, it just simply says it's an offence not to do it. What does that mean? Different authorities, yes. Bronwyn?
The seller would be likely to get a fine of some sort, I think. If they don't have a pool safety, I think they're liable. Even after settlement, they can still be liable.
Yes, I agree with that. But what about from the perspective of the buyer then? Is there any difference? If you were reading that and advising a buyer, can the buyer have different rights depending on the different breach?
They'd probably have you know, they could be liable as well. You think if they've gone ahead and settled, then they could be liable from, I think, isn't it 3 months after they have 90 days to get a...
That's right. So there may be some, and it actually does say that. It says, warning to the buyer, this is in the context of pool safety, if there's no compliance or exemption at settlement, the buyer does become responsible to obtain the pool safety certificate within 90 days of settlement. So that's right. Now, I'm looking at it. Rachel has identified the answer that I was looking for. And the answer is, in the context of failure to comply with the pool safety requirements, the buyer cannot terminate or seek compensation. That's a key difference. And in fact, if there's no compliance or exemption certificate, even though the seller may have committed an offence, as Bronwyn correctly identified, the buyer is responsible for fixing it up. So we have, in the one instance, on page 3, in the warning to the seller about failure to identify title encumbrances, an issue where the buyer may terminate or seek compensation. But if the buyer fails to comply with the pool safety requirements, they may be subject to penalty, but ultimately there's little the buyer can do about it. So you need to be on top of the contract clauses, look at the warning statements, the fine print, so that when clients come to you for advice before the contract is signed, or for advice if things go badly during the conveyancing process, you can identify with clarity the buyer's rights and entitlements, which directly relate to the seller's obligations. Any questions about that? So you see what I'm getting at? And it may be that many people would think that if the pool was incorrect, then the seller would have to fix it and there'd be recourse for the buyer to assist, but not necessarily the case. So that's the warning on page 4. Neighbourhood disputes, fences and trees. There's reference here to failure to comply with Section 83 of the Neighbourhood Disputes Dividing Fences and Tree Acts by giving notice of the order prior to signing will entitle the buyer to terminate the contract prior to settlement. Well, why is that the case? Why is it that if there's a failure to give notice of a tree or dividing fence order, the buyer can terminate, but if there's failure to comply with the pool safety requirements, the buyer can't terminate? I'm not asking for necessarily an answer. You can look at the explanatory notes to the legislation for some guidance on that. But Sarah says it affects the quality of title. Yep, and I think that's right, as opposed to a defect in title, perhaps. So you need to look at this from different perspectives. You need to be aware of what's in the contract in detail so that you can advise clients, but also think about what you would do, advise clients in the event of something going wrong, but advise clients in the event of them coming to see you beforehand. So encumbrances is not specifically defined. Title encumbrances is not specifically defined, but referred to on page 3. And likewise, tenancies is not defined, but further to specifically those are specifically referred to on page 3 as well. A couple of other things, and then we'll do case 7 and we'll call it a night. I want you to have a look at clauses 7.5 and 7.6. So these are on pages 10 and 11, goes over onto 11. So 7.5 deals with survey and mistake within the context of matters affecting the property, and it states that if there is an error or in the boundaries of the land, or an encroachment or a mistake in describing, which is immaterial or material but the buyer elects to complete, the buyer's only remedy is compensation. But if there is a material error, the buyer may terminate the contract. You know, the good thing about these sorts of clauses is that if you have a question in the exam about the buyer's rights in certain circumstances, and I specifically say to you that the buyer and the seller have entered a contract which is the 14th edition, you may not have to give me any case law. You might simply say, it's in clause 7.5. This is the contract between the parties. And if that's the agreement, then it doesn't matter that cases may have a different slant on it. Do you see what I mean? So I've got to be careful when I write the examination, which I've partly written, but not completely, in that you may have questions that are very easily solved by reference to the contract, but very badly punished if you ignore the contract provision. So 7.5 is a good one. 7.6 deals with requirements of authorities. And it says that a valid notice of a competent authority requiring work to be done must be fully complied with if it's issued before the contract date by the seller, if it's issued on or after the contract date by the buyer, and if any work that is the seller's responsibility is not done before settlement, the buyer is entitled to claim a reasonable cost. Any work that is the buyer's responsibility required to be done must be added to the balance purchase price. They're not really comparable provisions. They look it, but they're not really comparable provisions. Can you see why? Just have a look at 7.6 subsection 2 and subsection 3 and tell me why it's not really fair on the buyer. Okay, so Sarah says the notice could come about after settlement. That's true. But in both instances, I think we can assume that it's something before settlement. Let's say we're aware of it before settlement. Okay, so here's what I'm looking at. If the work is the seller's responsibility, then the buyer is entitled to claim it from the seller after settlement as a debt. Oh, who wants to chase debts? You know, you're chasing somebody who's probably moved to Argentina and they say, but it cost me $5,000. And you say, it's going to cost you $15,000 to chase that $5,000. What good is this contract? It's not worth the paper it's written on. As opposed to a situation where if it's the buyer's responsibility, then it can be added, it must be added to the balance purchase price. So there's better security there for the seller. Okay, last thing for this evening, let's hang in there. This is case number 7, so we're into the 22. Got the pens? Concentrating hard. If you're at home, please work this out before you listen to the answers. Right, so you act for the buyers who purchase a home for $600,000. They obtain approval to borrow $480,000. You undertake a building search before settlement. As a result, the council issues a requisition. The problem is serious. It requires extensive work to be undertaken by the sellers. The sellers agree to do the work, but ask for and receive an extension for 3 months. At settlement, the sellers present an invoice for $70,000 and ask the buyers to pay that in addition to the purchase price. That is, for the work done to fulfill the requirement of the council requisition. Your clients, the buyers, they have stretched themselves to the limit by borrowing up to the limit before mortgage insurers are involved. It's now 1 hour before settlement. Your clients seek your advice. The buyers had thought they would be paying $120,000 at settlement, including the deposit. Now they're asked to pay $190,000. What are the issues? What are the answers? What advice do you give to your client? Okay, we're getting some answers. If it's subject to finance, could terminate. True, but it's an hour before settlement, so odds are that finance has already been approved. Was it agreed, says Sarah, that they pay the works? Well, the council issued the requisition and the council gave the notice to the sellers saying, here, fix this. The sellers agreed to do the work and they asked for an extension, but they didn't ask for the buyers to pay for it. And they didn't offer to pay for it themselves. That was silent. Maybe the buyers assumed something. Leonie says, if there's an agreement, the buyers don't pay. Sarah says it's their property under legal title. They deal with the requisition. And I guess as far as the council is concerned, yes. But are the sellers just being cheeky in providing this bill to the buyers and saying, here, you pay for it? What does the contract say? Here we go. Some answers to do with clause 7.6. Rachel says clause 7.6 means the buyers have to pay. Andrea agrees. You're about half a millisecond behind Rachel on that one, Andrea. 7.6. So now we're getting a change of vote here. The vote originally was the sellers are responsible. Now we're getting some votes saying the buyers have to cough up. The buyers say, we didn't do anything wrong. What did we do? We didn't ask for it to be done. All we did was we bought this property for $600,000. If we'd known we were up for $70,000, we wouldn't be paying this. We wouldn't have bought it.
If the buyer had done the search and had to send it on to the seller, wouldn't you ask for the seller to do it at their cost? When
well, you might. You might. In this case, they didn't, but you might. If you're acting for the seller and you had a request of that nature, what would you say? Would you say, yeah, you better pay it, that's only fair? Would you do that? Andrea says,
not required under the contract.
Yeah.
So.
Andrea says, have a look at clause 7.6 sub 2. The reasonable cost must be added to the purchase price. No, 7.6.3, sorry, says Andrea. So you could maybe argue as to whether this is a reasonable cost or not. Now, bear in mind, this is an hour before settlement. What about time is of the essence? Is that going to have a bearing on your advice to the clients? Would you be saying, Well, it's all a bit late. You know, I wish they'd told us about this earlier. So we're just going to have to leave this. You know, we'll get an opinion or something, and we'll worry about it next week. Can you do that? You're an hour before settlement. What's the ramifications for a buyer if they say, "Look, we're just not going to settle. We're not paying it. We're not settling. It's not fair." Can it come back to bite them?
If they don't have the money to settle, and they weren't given sufficient notice prior, you know, you have to be given at least a few hours for your check directions and things to be given. So you would think the seller has to act reasonably and give sufficient time for the buyer to know that they're going to be asking for this extra money.
Yep. No, that's a fair comment. But what if I change it and say 4 hours before settlement? I'll say, well, that's a reasonable time.
It's not very good for your client.
No. See, specific performance, says Sarah. See, the problem is, one of the problems is 3 months extension could also be a time issue, pay in 3 months. So we're assuming that there was a request for an extension for 3 months granted, time to remain of the essence. If you're ever granting an extension, always say time remain of the essence. Finance could have lapsed throughout that time. Yes, that's a point. Only last a maximum of 3 months. That's a good point. So these are things that you might consider, but what if your finance is still there? Rachel said, call the bank. Right, you phone the bank, we need an extra $70,000. No, we're not going to give you $70,000 more because that will push you into mortgage insurance territory, and it's going to take us 2 weeks to run this by your mortgage insurers and get that organised. So we don't have $70,000 for you today.
You'd have to ask for a further extension so you can sort the money out.
Ask for a further extension. The seller says no. Settlement 4 o'clock, time of the essence. You're pretty much stuck, aren't you? You've got some problems as a buyer. So time is of the essence. That's a problem from the buyer's perspective. Clause 7.6 says if the seller does the work, which is the buyer's responsibility, the seller may add the cost to the purchase price. Well, why is it the buyer's responsibility? Wouldn't you argue that? If you're the buyer, you'd say, well, it's not our fault. Why should we have to pay for this work? And I know what Andrea and Rachel will say. They'll say, have a look at clause 7.6, because it says, if the requisition issued after the date of contract, but before settlement, and the seller does the work, the seller may add the reasonable costs to the purchase price. Now, is it reasonable expense at $70,000? That's a good point. Is it reasonable? And you'd have an argument about that. Where would you, if you wanted to argue this, what are you just going to write letters to and fro? Or what would you do about it? You'd probably seek an injunction or declaration from a court, probably the district court, I should think, if you had to, to get a resolution. From a practical perspective, you could try and raise the fund from other sources. You could note that $480,000 represents 80% of the purchase price. And for those of you that have been involved in buying real estate, you'll know that 80% is critical, because that's typically the cut-off point at which buyers have to consider getting mortgage insurance. Beyond that, you've got no time to organise mortgage insurance or additional borrowings. Now, you have to advise your client that the seller may terminate the contract. So what if the sellers play really hardball here? They say, no extensions. We've been waiting 3 months. We did all this work for you, and now you're being so miserable, you're not even going to pay for this work that we did for you. We spent $70,000. We don't get any benefit. You're the ones that are buying the property. No, if you don't settle today, we're terminating the contract. What might happen to your buyers if they terminate the contract? The sellers, that is. what could they stand to lose?
Deposit.
They could lose the deposit. Now, Sarah says 9.2, the sellers could affirm the contract, and they could. If there's a breach, generally parties have an option, but you have to elect either to affirm the contract, say we're going ahead with it, which is what you'd do if you're looking for specific performance, or we are rescinding the contract. And that is where you would seek to terminate the contract, which is where you want to resume the property, forfeit the deposit, which is what I'm after, sue the buyer for damages, and resell the property. The sellers could seek an injunction against the buyers, perhaps. Yep. So it depends on what the sellers want to do, but the buyers may find that they lose their deposit. What if the deposit happened to be more than 10%? Is there any other special rules that might apply? And this is getting on a bit. Yep.
Instalment contract.
Exactly, instalment contract. And that, if it was an instalment contract, that would buy the buyers more time because the sellers don't have a right to immediately terminate. They must give notice. So at least that buys you time. So, you know, if your buyer was going to pay 10% deposit at the start, they're probably better off paying 10.5% because then it gives them that little bit of insurance because it becomes an instalment contract. So,
but then isn't there a risk of the seller doing the same thing,
yes.
pushing the settlement out as long as they want?
It could do. Yes, it could do. So, and if the buyers don't settle, they may lose their deposit, but they may be more than that. The sellers may sue them for damages in addition to that. So all of this is happening an hour before settlement, and the clients are asking you for advice. And I just want you to think about two final things as we leave this evening. That is, remember there's a removal truck sitting outside the home and some bloke saying, what am I supposed to do here, mate? I've got all this furniture. And the second is, your employer is saying, you're doing all this work, are you going to charge additional fees? And are you going to charge additional fees? And the buyers are saying, now you want to have a go at me as well. Everybody wants to have a go at me. You see what I mean? All right. Thanks very much for your patience. Think about those issues and we'll see you next week. Sorry it was a late session. All the best. Bye then.